Being an executor is both an honor and an obligation. It is quite the honor that the person who prepared the will nominated you as the executor, the person with fiduciary responsibilities to handle the estate administration process and to act in the best interest of those affected by the estate administration. This means the beneficiaries in the will, as well as creditors of the estate. And it's an obligation because you have those fiduciary responsibilities. You are to act in the best interest of those affected by the estate administration process. And that includes creditors. I want people to think about executors and the role that they play when they're preparing their wills. You can hash this out with your estate planning attorney and think about who would be the appropriate person to act proactively and diligently and keep the estate moving forward on the right track to the benefit of those involved, as opposed to a person who's not going to handle things proactively and really just sort of wait for the next shoe to drop. And the estate will easily fall off the tracks and start having all sorts of problems. I can tell you that I've worked with executors who are out of state who actually are better for the job than somebody, let's say, in state. It's not just of location that makes the difference as far as a person who's suitable to be an executor, but how they will handle this type of job. Will they command the respect of others? Will they work well with professionals? Will they open the mail? Will they check their email? Will they get back to phone messages and so on? I can tell you that I've worked with people out of state who I've been able to email documents to. I know they're going to print them out. They're going to take them to the notary that they know that they have ready to be able to notarize documents with, and they'll FedEx those documents back to me and I'll have them the next morning. It's that kind of back and forth and being prepared that makes all the difference versus the person who's very laid back, who's really not taking proactive actions, who's really just kind of waiting around, maybe not opening the mail, maybe not returning phone calls, answering emails, and doing the things that need to get done. An estate is opened in surrogate's court, and then eventually we want that estate closed. We do not want the estate to linger when it does not have to. We want to get the job done. So again, being an executor is both an honor and an obligation. You're going to think about it when you're preparing your will and working with your estate planning attorney to think about who's the appropriate person and alternates to line up. Now, very importantly, when you do nominate a person in a will, they have the right to seek being appointed as such. You're giving them the card saying, here's the card, go ahead, seek being appointed. And I can tell you one of my worst experiences was with an outdated will where there were executor nominations that were very old, and the people who were nominated did not want to act, but they had that card. They were nominated. And so hemming and hawing and not sure what to be done. In the meantime, we'll just let things sort of linger and we'll kind of still fuss a bit. Maybe we'll hire an attorney. Maybe we'll see. It was a terrible, terrible experience for me, as well as for my clients who were the people who were affected by the estate administration process. So very important, get your wills updated and think about your executor nominations. You are giving the person you nominate as executor the card to move forward with their nomination or not. If they do not decline, and that's called a renunciation, then they move forward, and that alone, if it's the wrong person, can wreak havoc on an estate and all of those affected by an estate. Now, wouldn't it also be nice to know if you are nominated in a person's will? You're nominated as the executor. Do you know where the original will is located? Are there other wills out there that are all of a sudden going to come into play at some point and cause confusion? It would be really wonderful to know. Very important information. Where is the original will? Is this the only original will out there? You are the nominated executor, and this is up to date. You intend to move forward with your executor nominations, because knowing that kind of basic information can mean all the difference. That nominated executor can move forward with his or her attorney, file appropriate paperwork with surrogate's court, know that they're moving forward, intending to act as the fiduciary for the estate, and perhaps, depending on the facts and circumstances and working with his or her attorney, determining what protective and proactive measures can be taken even before they are appointed by surrogate's court. And that alone can mean such a huge difference. My goodness, if you've got real estate involved, if you've got people living in the house, or perhaps nobody's living in the house, or perhaps you've got even some other assets that you want to get a handle on right away so they don't lose value, you need to know you are the nominated executor. There are no other documents out there that are going to cause confusion. You intend to move forward, and therefore you can work with your attorney to take some protective, proactive measures. So again, being an executive, my goodness, it's an honor, but my goodness, it is also an obligation. Choose wisely in your nominations, in your will. And then when you are nominated in a will, wouldn't it be lovely to know this information and to know some other basic information that can help you get on the right footing as you move forward in the estate administration process? This is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship, and I hope to see you on another video.